You were involved in a car crash and you're thinking about bringing a lawsuit, but you hear you may have to give a deposition and you don't know what a deposition is. Well, I'm here to explain to you what a deposition is and what it entails. Hi, I'm Frank Nunes. Thanks for joining me. I'm a California personal injury attorney practicing in the state of California. So you've been asked to give a deposition and you have no idea what a deposition even is. Well, first of all, a deposition is a question and answer session where one party will ask you questions and you give answers. But unlike other questions, it's not an aptitude test. You're only obligated to testify as to what you heard, smelled, felt, recalled, or saw at the crash site. You're not obligated to guess. You're not obligated to speculate. So now here you are. You know what a deposition is. What kind of questions can they ask you at a deposition? Well, the answer is it's a very vast and wide scope of questions they can ask you. As long as the questions are reasonably calculated to lead to the discovery of information that can narrow the scope or prove some of the issues at trial, then you can be asked that questions. However, there are some exceptions. Communications between you and your attorney are typically privileged. And that's the most common exception to what can be asked at the deposition. So if you have a conversation with your attorney about the deposition before you go into the deposition, what is said in that conversation is between you and the attorney questioning you at the deposition cannot ask you about that question. There are other exceptions that I'd be happy to explain to you if you'll take the time to pick up the phone and call me at 559-436-0850. You've got questions about depositions and I've got the answers. I'm Frank Nunes. Thanks for watching.